Okay, you're all set.
Oh, good. Okay, let the record show that today is March 16th, year 2025. Time is approximately 8:32 a.m. We're via Teams and in the steward's office at Sunland Park in Sunland Park, New Mexico. Present today are stewards Reese Howard, Jeff Waxler, myself, Violet Smith. Also present is New Mexico Racing Commission in-house attorney Richard Bustamante, New Mexico Racing Commission Chief Investigator Lisa Johnson, trainer Toby Keeton, his attorney Mr. Clark Brewster, and that's via Mr. Blackburn. Also, does Mr. Brewster have any other people in attendance that I cannot see or know?
Yes, ma'am. With me is Joey DeAngelis, also a lawyer in this matter. We have filed our Pro Act Vice, got approved by the New Mexico Bar Association, and it is just waiting to be approved by the chief steward at this point for this hearing.
Okay, and that's via Mr. Blackburn also?
Mr. Blackburn is our local counsel, and we've applied Pro Act Vice to be approved. And so we would ask that that be dealt with at the outset here before we start the hearing. On behalf of Mr. DeAngelis.
Okay. We can only have one computer on in one room because otherwise it's going to have an echo. Okay. Do the stewards have any objection of allowing Mr. Joey DeAngelis to join us this morning?
No. No.
Okay. Okay. All right. That's so approved, sir. Wow. Something's got to give here. Okay, let's continue. At this time,
Can you hear?
we're here in connection with the notice.
You want to sit over here, you can.
Okay, somebody's got to turn off a computer. I can't do this.
If you want to pull one over here next to you.
Hey, Billy, would you mind muting yours? I think yours is the one echoing.
Bill, can you mute yours? I am.
Oh, it shows
I'll
you're
do it
live.
here.
There we go.
Does that fix it?
That might work.
Yep.
All right.
Okay. All right. At this time, we're here in connection with the notice of hearing for a continued summary suspension hearing. This was per request of Mr. Keaton's attorney. Mr. Keaton was notified that we'd hold this hearing this morning on this summary suspension hearing, and this hearing is the sole issue as to whether the licensee should remain suspended pending a final disciplinary hearing and ruling for the following violations. Multiple violations have been listed in this notice of hearing. They are positive findings for the drug clenbuterol. Not clenbuterol, carmodorol, which is a class 1 penalty A drug. At this time, I want to read that this is a quasi-judicial hearing, which means in nature, which means the rules of evidence need not apply as they would in a court of law. Also, I'm going to read a rule into our record, and it is titled Behavior, and it says each party, witness, attorney, or other representative shall behave in all commission proceedings with dignity, courtesy, and respect for the commission, the presiding officer, and all other parties and participants. Attorneys shall observe and practice the standards of ethical behavior prescribed for the profession by the code and professional responsibility. Any individual who violates this section may be excluded from the hearing by the presiding officer for a period and on condition that they are just or may be subject to other just, reasonable, and lawful disciplinary action prescribed by the presiding officer. At this time, I will, the parties that are going to testify in this hearing this morning, as they are called to testify, I will swear them in at that time. At this time, I'm going to turn this hearing over to in-house attorney for the New Mexico Racing Commission, Mr. Richard Bustamante.
Thank you very much, and good morning to everybody. For time's sake, basically, I will pass by a brief opening statement, and I would call to the stand Chief Investigator Lisa Johnson.
I'm having a hard time hearing him.
Can you come over here? If you turn that on, I'm afraid we're going to get an echo again.
Mr. Chief Steward or Ms. Chief Steward, we
Yes.
would not like to waive an opening statement. If Mr. Bustamante is not going to make one, then it would fall to us to make one. We would like to make an opening statement prior to the presentation of witnesses.
Well, okay. I'm waiting on Mr. Bustamante to see what he's going to do here.
Stuart Smith, I have no objection if Mr. Brewster would like to make a brief opening statement at this time.
Okay. All right. Mr. Brewster, proceed, please.
I'll defer to Mr. DeAngelis for the opening.
Thank you. So first of all, we have a pending motion, which is the motion to vacate the summary suspension on procedural grounds. The basis of that motion is the U.S. Supreme Court decision in Berry v. Barchi. Berry v. Barchi was a horse racing case out of New York, quarter horse trainer. The issue in that case was whether the post-suspension procedures in a summary suspension complied with due process. The U.S. Supreme Court held that an indefinite summary suspension is not permitted by due process, and that a prompt post-suspension hearing has to be on the merits and relate to a final ruling. It's pretty apparent based on email communications and rulings and restrictions that this is not the hearing on the merits that's required under Berry v. Barchi. That hearing really hasn't been set. We have no indication of when that hearing is going to be. Email communications have indicated it's likely going to be months at the earliest before that occurs. The suspension in Berry v. Barchi was only 15 days, and they said that timetable was too long, the U.S. Supreme Court. We're well past that point with really no end in sight. And so regardless of the evidence presented at this hearing, the inability of the commission to move forward on the evidence on a merits hearing at this time requires the summary suspension be lifted on constitutional grounds.
Okay, so noted, sir. At this time, your motion is going to be denied. We're in the state of New Mexico, not New York. So
it's a federal decision on due process, which does apply to New Mexico.
Okay, well,
I appreciate the ruling. Thank you.
You're right. At this time, if you've concluded your opening statement, I'm going to turn this over to.
I have not. That was just a preliminary motion to the opening. I apologize.
Now and we have no issue with doing this, sir. But I just want you to be aware that we have very limited time this morning. And
yes, I'll be very brief. Yes.
Thank you. Thank you.
Yes. So the issue in this hearing, as stated by email correspondence in the notice, the sole issue is whether a summary suspension must be imposed or should continue. The fact at issue that must be found in this hearing is whether the licensee's actions constitute an immediate danger to public health, safety, integrity, or welfare. Under the plain terms of Commission regulations, that is a finding that has to be found by preponderance of the evidence. And although the rules of evidence do not apply, New Mexico regulations 15.2.1.9 A6B says that hearsay evidence alone is an insufficient basis for a ruling. And obviously this is a ruling. That ruling does not distinguish between final disciplinary action or a summary suspension. So the question here is going to be whether there is any evidence that is not hearsay that is going to justify the finding that that Toby Keeton's actions constitute an immediate danger. Now let's turn first to the evidence that we've received on chain of custody. In order to establish that there is a positive finding in this case, they're going to have to establish some basic evidence about chain of custody. Just go straight to number 2. Or actually number 3. Go straight to number 3.
That's one. You want B or what?
Go to A2, please, Tracy. Next. The evidence that we've seen in this case so far, there is no evidence of a chain of custody in this case. I took these requirements from case law. There's no daily log showing who had access to the samples. We have no idea whether the samples were sealed, when they were sealed, by whom. You're not going to see any evidence of the identity of the person who placed them in a secure location. You're not going to see any evidence of anyone with personal knowledge who, I can't see.
You get that. Yeah.
You're not going to see any evidence of when it was placed in a secure location, how it was secured. You're not going to see any evidence of anybody who removed the sample for shipping. You're not going to see any evidence tying the sample number to a container that was sent to industrial. And you're also not going to see any chain of custody from the laboratory. There's plainly no evidence linking the sample to the horses, and no evidence establishing that that sample was in the same condition at the beginning and the end of testing.
These are all essential.
And these are all essential predicate findings to even admit this evidence into the record, even for this hearing. Now, we also have, actually, let's skip this for now and go to number 6. The only evidence they're going to present is a single sentence, a conclusion, a hearsay opinion from a laboratory report that says carmoterol was detected in blood. The question you need to ask is whether this is going to be sufficient evidence that is reliable to make that finding. Our position is that it's not, for several reasons. The first of which is that the chemical makeup of carmoterol is easily confused with other substances. We go to the next one. In particular, one substance potential for confusion is cetirizine, which is commonly known as Zyrtec. Cetirizine N oxide is a metabolite. We have an expert report from Dr. Jesse Phillips. It's exhibit 14 that goes through this. But they have an identical molecular weight and a similar chemical makeup. Cetirizine is a threshold substance. And if you look at exhibit 16, which is an email from the Texas Racing Commission, cetirizine was detected in the water at racetracks where Toby Keeton's horses were housed. There's a substantial likelihood that these could be confused if the laboratory was not using a method designed to distinguish these compounds. We have no evidence of what that method was, so that you can't make a finding that this is a reliable method. You go to the next one. It also has an identical chemical formulation to a group of substances called oncarines. Oncarines are derived from a plant called cat's claw, which is sometimes included in feed, on label or off label. same issues. There's a similar molecular weight, similar structure. You can confuse them easily if you haven't calibrated the equipment correctly or developed a method that can distinguish between these two compounds. Go to next one. And here's the legal issue with using, regardless of these, of those, the issues with the testing. The single sentence that says carmoterol was detected in blood is hearsay. It's an opinion offered by somebody who's not going to be testifying at this hearing. And it's out of court. And it's being offered for its truth, being carmoterol was detected in blood. That is definition of hearsay. This is not the type of hearsay that falls within any exception. The case law on that point is the New Mexico Supreme Court decision, State v. Aragon, says they're not public records, they're not business records, because they're made primarily for use in court. So it is hearsay. It doesn't fall within exception, and it's not the type of evidence that you would rely upon by itself to prove that carmoterol was detected in blood. And that's apparent from really 3 points. The first of all is that there are routinely uniform requirements to admit lab certificates and evidence that require disclosure of the underlying data. The second one is that under ISO 17025 and RMTC standards, you're not allowed to accept a report without the litigation packet. That requirement is because this is not the type of evidence you rely upon by itself to make a finding. And finally, the routine production of these laboratory packets in litigation is itself proof that even prosecutors and attorneys litigating these know you need more than a certificate. You have to produce the underlying data. We don't see that here. And so this is hearsay. It's not admissible. And even if it were admissible, you wouldn't be able to rely on it alone. The fact they're not calling the chemist means that you can't accept this evidence. And go see. Actually, let's skip to D. D. It's 14. And finally, even if you accept and admit the evidence of carmoterol, the positive finding, contrary to the rules against using hearsay, you have to have additional evidence that there's some conduct, some involvement by Mr. Keeton. You go to the next slide. So this is the difference in standards between a summary suspension hearing and the absolute insurer rule. A summary suspension is tied to the trainer's actions. Insurer liability is not. At the hearing on the merits, the standard is whether anybody caused this, and it's regardless of the acts of third parties. You go to the next slide. For that reason, courts uniformly hold, applying the absolute insurer rule, there's about a dozen, but here I think are the best two, that there's no presumption that the trainer was involved when there's just a positive finding. You have to have additional proof. And that the issue in both of these cases was whether the absolute insurer rule violated due process as an irrebuttable presumption. Both cases held that it didn't because it is not a presumption. It is simply a condition of licensure. There's no factual component tying the positive to a trainer just because it's found in a horse, given the scope of liability. And so the question is going to be, what evidence do they have? Yeah. What evidence does the commission have that shows knowledge by Mr. Keeton of the circumstances that caused this positive finding? Is there any involvement by Mr. Keeton? Was he even aware that there was a possibility this drug might make its way into the horse? Did he authorize it? Is there any evidence to that point? And the answer to that question is going to be no. And so with that, we'll pass it off to Mr. Bustamante to present Ms. Johnson.
Thank you, sir. Mr. Bustamante.
He's muted.
No.
We can't hear Mr. Bustamante.
Okay, can you hear me now?
Yeah.
Yes, sir.
Okay. If you could swear in Investigator Johnson, please.
Ms. Johnson, would you please raise your right hand? Do you swear the testimony you're about to give in this hearing this morning will be the truth, whole truth, and nothing but the truth?
Yes.
Please state your name for the record and how you're licensed.
Mr. Johnson, I'm the chief investigator for the New Mexico Racing Commission.
Thank you. Mr. Bustamante, you may proceed.
All right, thank you. Investigator Johnson, if you could briefly describe what do you do once you receive an adverse analytical finding?
Okay, hang on, Richard. We're having a problem.
Okay.
Come over here and see what happens. Testifying from him. First,
We can hear you, Lisa.
I won't buy it.
Okay.
Okay, just to repeat, please briefly describe your process once you receive an adverse analytical finding.
So I'm the one that receives the results from the industrial labs, who is our official laboratory. So once I receive the certificate of analysis from the laboratory, it then I contact the trainer and
Billy, could you mute? Thanks.
okay. All right, so once I get a finding from the lab, then I contact the trainer. I usually give them a phone call to let them know that they have a finding for a medication violation. I then follow that up with a letter of notification. In the letter of notification, it will list the pertinent information as far as like the sample number associated with the horse, and it also gives them the right to a split sample, and it goes over some of the rules as far as like the split, and that the horse will be placed on the stewards list until the case has been adjudicated. Along with the letter of notification that goes out, there is attachments to that. There will be the certificate of analysis. There will be the test card that will establish the sample number associated with that particular horse. And then there will be the program page, which is the official program for the race, which will have the horse's name listed on it, along with the trainer and the owner. So I also send the exact same, well, and not the exact, because it would have a different person's name on it. The owner's name and address would be different, and a little bit of the information. It just lets the owner know that the trainer was contacted about a medication violation, and it goes through the complete same reference to the material and the attachments.
Thank you. Can you tell us, have split sample testing been requested in these cases?
Yes.
Okay. Investigator Johnson, turning to the commission exhibits 1 through 8, are you familiar with the contents of those documents?
I have to find out where they're at.
1 through 8 and 1 through 7.
Okay.
All right. Again, just generically, regarding exhibits 1 through 8, are you familiar with the contents of those documents?
Yes.
Okay. All right. Do you yourself produce any of the documents in these exhibits?
I am the author of the letters of notifications to the trainer and the owner.
Okay. Does any other commission staff member have responsibility to create any of the documents in these exhibits?
No.
Okay. And regarding the documents that aren't created by commission staff, the documents you receive from others, do you regularly receive those and rely on those in the course and scope of your work on medication violation cases?
Yes.
Okay. And regarding those other documents, do you rely on the contents and the information therein regarding their accuracy and trustworthiness?
Yes.
Okay. Regarding all of the documents that are contained in exhibits 1 through 8, does the commission maintain these documents for historical purposes and for record keeping?
Yes.
Okay, all right. Honorable stewards, at this time, the commission respectfully ask for the admission of commission exhibits 1 through 8, please.
I object to the hearsay statements of those authored by any person that's not testifying before the commission today. We've got a number in those exhibits, 1 through 7 particularly, of the certificate of analysis from Industrial Lab. Those are clearly hearsay documents. As Chief Stewart Smith mentioned, you can receive hearsay, but it cannot be relied upon for a ruling pursuant to the express rule under New Mexico Racing Commission rule. So I object to the hearsay nature of them, and to the extent they're being offered for the stewards to rely upon in making a ruling, that would be directly contrary to the rule, express rule that has been cited in our opening statement, in our brief as well. So I object to that. It's incumbent upon them now, if they're seeking a penal effect of suspension at this point in time, and that's what I think is being requested, a continuing suspension. It's incumbent upon them to put on evidence of a chemical positive that's reliable, that the commission can rely upon with expert testimony, documented standard operating procedures of the lab, and the fact that it's distinguishable from other common medications that wouldn't be a violation under the New Mexico rules. Just a hearsay statement is inadequate for a ruling. Secondly, there's been repeated requests for months now for this underlying documentation from the lab, called a litigation packet that's set forth in a contract with the lab, but it's never been produced. It's going to turn out in this case, I predict for you, that these alleged positives aren't positives at all. And the fact that they're not scientifically reliable, sufficient to have a produced lab packet, is clear evidence of that. So notwithstanding for the limited admissibility, to which I object, if they are received, they're not to be used as the sole fact basis for a suspension. And that's my objection. Thank you for your patience in allowing me to unfold that.
Thank you, sir. So noted.
Stewards, I respectfully point out based. Oh, I apologize, Stewart Smith. Please continue.
I have a question. You mentioned a certificate of analysis that you receive, right?
Are you talking to me or the witness?
I'm talking to Lisa.
Okay.
Oh, okay. Wasn't sure.
Okay, I'm sorry. You mentioned a certificate of analysis, and you received that from who?
We received that from Industrial Laboratories, who is our official laboratory.
Okay. Is that document notarized and signed?
It is.
Okay. Okay, you may proceed, Mr. Bustamante.
Can't hear you. Oh.
Okay, honorable stewards, basically, we need a response, an answer to my motion to admit exhibits 1 through 8.
I'm going to admit those Thank you, sir.
Thank you. Investigator Johnson, if you could take a look, please, at NMRC number 1.
Okay, the letter of notification dated
Okay.
February 11th, 2025.
Generically, who receives those types of notices of post-medication violations?
If we're talking the letter of notification, it would be the trainer and the owner.
Okay. In this instance, in NMRC Exhibit 1, who would those individuals be?
This is Mr. Keaton, who is the trainer of record, and I don't have the other one pulled up, so I couldn't tell you who the owner was. Mr. William Tiffey is the owner.
All right. And basically, is it fair to say essentially that the notice of post-race medication letters, essentially they are basically packets that you put together and provide the trainer and the owner?
Correct.
Okay. If you could continue scrolling down, please. And the certificate of analysis, essentially, where does this come from?
This comes from Industrial Laboratories. They're located in Denver, Colorado.
And the affiant, Tim Kruger, who is he?
He is the senior chemist who signed the affidavit as of reviewing the results or the how they came up for the testing.
Okay. And I see it has a sample ID of E547596. Do you see that?
Yes.
Okay. And what I failed to see is why is there no identification of the horse on this final positive report?
The laboratory does not know who the horse or any of the trainer or owners belonging to that sample number.
All right. And regarding this document, what does it tell us regarding this specific adverse analytical finding?
Well, like you said, it gives us the sample number, which is E547596. It was collected at Ruidoso at the Downs at Albuquerque. The collection date is September 2nd. It also lists like authorized medications that could be found in the sample, which lists Lasix. It gives the sex and the gender, and it also says the type of testing samples that were received was blood and urine, and that it was a post-race test. It also says on here the date that they received it at the laboratory was September 4th. It gives the seal number of the cooler and the laboratory ID that is assigned once it gets there. And it also says that sample was unacceptable and secure.
Would you receive this type of report if the sample wasn't received secure and in good condition?
I don't believe, I've never seen an affidavit written where it was not acceptable, secure. If something happens to the sample, we are notified by email.
And what does the adverse analytical finding on this document tell us?
It says that it was carmoterol was confirmed in the blood.
Okay. Backtracking a little, Investigator Johnson, all the samples, the exhibits we're going through regarding testing results, were these all on one day of racing?
That's correct.
Okay. And would the same, who was responsible for collecting the samples?
The New Mexico Racing Commission test barn.
Okay.
And our
who
official
had them-
veterinarian and the vet assistants that are assigned to the test barn.
Okay. And who is the official veterinarian?
Dr. O'Sullivan.
Okay. Uh, did Dr. O'Sullivan obtain these all these samples for that day?
Yes.
All right, thank you. Please continue to scroll down to the next document. Okay, this is the test card, and I do see the identifying number of E547596, and I see how it is related to the horse Shoeless. I see a few other signatures there. What can you tell us about the witness signature and who that person is, if you know?
So the witness signature is the person that is with the horse from the time that it comes off the racetrack to the test barn. And the witness's license number is associated with the name. I'm not sure how to say the first name. Carzo.
And essentially, with respect to these test cards, is the witness always somehow connected to the horse that's being tested, and the stable and perhaps the barn?
Not always. The groom can be. I mean, on trial days, there's a lot of horses in trials, and so barns may ask for help from other trainers. So, it could be from their barn or it could not be from their barn, I guess is what I'm saying.
All right. And where it says blood sampled by, do you know whose signature that is?
Yes, it's identified by the license number, and it says, I don't know, Feliciano Carrazzo
Okay.
or Carzo.
And is any commission staff member responsible for overseeing the creation of this document?
Yes, the test card is filled out, probably goes through two or three different people. So when the horse arrives at after the race, they are notified what horses are coming to the test barn. The clerk or the secretary will then start the process of filling out the sample card. She will put the date of the race, the name of the horse, the tattoo number, the color, the sex, the age. She will put in where it finished and what race, the track, and who the trainer is. And then from the blood sample, the urine sample, and the witnesses are all filled out by the official vet or the person that is certifying taking the urine.
Is it fair to say that the commission vet oversees this whole process, including the completion of the test card?
That's correct.
And if you could continue to scroll down, please. Is this considered the program page?
This is the official program page for September 2nd. It's for the 10th
Okay.
race.
And I see the first listed horse is Shoeless. What can you tell us what this document tells us about Shoeless that's of relevance here today?
It has on there who the official owner and trainer are, which is listed as William Tiffy et al. And Mr. Toby Keeton.
And if you could continue to scroll down to the next document. The Equibase chart. Again, tell us exactly why this is relevant and what information this provides the stewards regarding shoeless.
So this is something that I add to the case file because it's the official chart of the race. It goes over the value of the race. It goes over the wind speed, the weather. It also has the name of the horse listed on here. It is the number one horse listed. I think it placed third, and it also has the wagering information on it also.
I
And
see
it also lists who the trainer and the owner is.
Okay. So essentially, in terms of trainer and owner, it's the same information that was on the program chart, correct?
Correct.
All right. Thank you. Investigator Johnson, let's move to, please scroll down. All right. We're looking at the uniform classification guides. And if you could continue to scroll down, please. Investigator Johnson, I see that essentially carmoterol is not listed there. How does the commission handle adverse analytical findings where the drug is not yet listed on this chart?
So in our rules, it indicates that if it is not listed in the ARCI drug pamphlet, that it would be a class 1A, and then it is, we would reach out to the RMTC to find out what the recommendation of the classification is going to be. Sometimes they'll keep it a class 1A. I've seen where they've changed the classification to a 2A. But it is up to their scientific board that works with the ARCI, or not the RMTC, to determine what the classification is going to be.
Is it fair to say that a 1A classification is the highest or the most serious?
That is correct.
All right. Please continue to scroll down. And Investigator Johnson, we're looking now at portions of the commission's administrative rules. How is it generally speaking, in this instance of a medication violation allegation, how is it that you select what rules in order to put together in this packet?
I try to give them all the rules that are pertinent to the case. As far as I don't believe Mr. Keeton had an assistant trainer, so it explains why the horse is ineligible. It explains what's going to happen to the horse while it's ineligible. And then it goes on to other rules that are like the medication and prohibited substance. It explains why it's a class 1A. Goes through the classification of why that is, and basically what I just explained. What'll happen is our RMTC will assign the penalty classification.
Investigator Johnson, is it fair to say that these applicable rules we're looking at, as well as the chart of drugs that we were talking about earlier, are those documents basically relevant and applicable to all of the other alleged medication violations that we're dealing with today?
Yes.
Okay, all right. Investigator Johnson, if you could please pull up Exhibit 2.
If I may, Mr. Bustamante,
Yes, sir.
if you're going to ask the same questions on 2 through 7, we would stipulate that you're asked the same questions and the same answers would be given for each one of them. And in light of the ruling that they're going to be received as exhibits, there will be no further need to establish foundation. And so just to speed things up, we would receive 2 through 7 on the limited ruling of admissibility, subject also to my objection that they cannot be the sole basis for suspension. But I don't think we need to go through each one of these unless, for some reason or another, the stewards want to hear all these questions over and over again.
You know, Mr. Brewster, that's very kind of you, and I appreciate that for time-saving device. And just for the record, I want to clarify that Exhibit 2 would have deals with dashing trests. Exhibit 3 for Anguila Rapida. Exhibit 4 for He's Got the Look Z. Exhibit 5 for Mountain Air. 6 is Just Good Wine. And 7 is Visa. And that basically in each one of these packets, the information is that Mr. Toby Keeton was the trainer. There's various owners, and that the adverse analytical affidavit from the lab, industrial lab, indicated carmoterol. So thank you. I appreciate that very much.
I'm just following the lead of our Chief Steward Smith, who said, let's move it along. So that's what I'm done to do.
Much appreciated, Mr. Brewster. Thank you so much. Investigator Johnson, let's scroll down to Exhibit 8, please.
Let me see if we can find that.
All right. It may be in a separate attachment. Okay. Do you recognize that document?
Well, there we go.
There
Okay. This is the ARCI Online Comprehensive Ruling Report on Toby Keeton.
Okay. Focusing, can you tell us, I see 92 total rulings there. Are there past rulings for medication violations?
Yes.
And if you know how many are listed there on the comprehensive ruling regarding medication violations?
There's a total of 92. I would not be able to, I'd have to go through it all to count up how many would be medication violations.
Okay. But in your review, are there prior medication violation rulings in this comprehensive record?
Yes.
Okay. All right. Thank you. All right. Investigator Johnson, anything additional to add? First of all, let me ask Investigator Johnson, were you present during the sample collection at the test barn?
No.
Okay. Were you present when the official veterinarian packed, labeled, and basically sent the samples off via a courier pickup?
No.
Okay. All right. Investigator Johnson, thank you very much. Honorable stewards, I would certainly request the opportunity to make a brief closing statement once Mr. Brewster has completed his presentation. And thank you, Investigator Johnson.
Okay. Mr. Brewster, would you like to cross-examine Ms.
Yes,
Johnson?
ma'am. I have a few questions.
All right, sir.
Ms. Johnson, do you have any evidence from any source whatsoever that Mr. Keeton administered or caused this drug to be given to any of the horses of the subject of this hearing?
No.
Have you ever interviewed Mr. Keeton or anyone in his barn to try to understand how this medication or one mirroring such medication was found in any of the matrices taken from the horses post-race?
I have not gotten to the part of the my part of the investigation as far as interviewing Mr. Keeton.
Have you interviewed anyone in his barn or frankly the test barn to try to understand how there was an adverse analytical result reported in any of the samples?
As I said, my investigation is not completed.
I know, but I'm asking the question so we have it for the record. Have you interviewed anyone, either in the test barn or in Mr. Keeton's training operation, to try to understand how an adverse analytical substance was reported in any of these samples?
Not yet.
No. The answer is no?
I said not yet.
Okay. As we sit here today seeking a summary suspension, the answer is you've spoken to no one on that issue. Am I correct?
Mr.
Yes.
Brewster, I think that's been asked and answered. Please move on, sir.
Okay. Well, I just want to make clear for the record, in the event there's an appeal, that we have a clean record and not supposition at that point. Thank you.
I think it's very clear. Thank you.
Okay. Ma'am, now, it's been, I think the races that we're talking about were on September 3rd. Am I correct?
No,
What date were they?
September 2nd.
Okay, September 2nd. And they were conducted in Albuquerque, but they were planned to be raced at Ruidosa, correct?
Yes.
There was a rather somewhat urgent relocation of the horses and the races to be conducted due to some catastrophic weather events. Am I correct?
Yes.
As a matter of fact, these horses were stabled in Ruidosa. I think the Rainbow Futurity was already run, and then it was decided that given the fires and flooding that was going on, that the races had to be transferred to Albuquerque. Am I right?
Correct.
Have you been told that there are a number of compounds that are chemically identical in testing to carmoterol that is present in the water at racetracks?
The only one that has told that to me is you.
Well, have you seen the materials in Texas where they actually tested the water and found cetirizine, which is a chemical compound identical to carmoterol, in the water itself?
No, I have not seen any of that documentation.
Have you caused any sampling to be done either at Ruidosa or at Albuquerque to determine whether, given the weather conditions and what was happening at Ruidosa, whether the water had gotten contaminated with human medications and caused these positive tests?
No.
Okay. Have you inquired of that any of the testing lab personnel?
No.
Have you asked that either the chemist or the people at industrial, the lab, the primary lab, whether their testing was able to determine the difference between cetirizine and carmoterol?
No.
Okay. You were asked about the certificate, and I think it was Chief Steward Smith that pointed out that these certificates of positive were signed, correct?
They're assigned and notarized, yes.
Okay. If I could, I want to direct your attention to our exhibit number 9, which is the State of New Mexico General Service Department contract with industrial, okay? And I'm going to show you, first of all, I'm going to show you page 11 of that contract that was in place between New Mexico Racing Commission and
Or do you want to share screen?
I want to share the screen.
Could you unshare your screen, whoever's sharing screen now, so we can share ours, if you wouldn't mind?
Mr. Bustamante.
believe, yeah, here it comes, Mr. Brewster.
Thank you. So let's go to the first page of Exhibit 9 if we could, and we'll move to introduce Exhibit number 9, which is the Racing Commission contract with the primary lab industrial. Yeah. This is the first page. Ms. Johnson, have you ever seen this contract?
Yes.
Okay. I want to direct your attention, just in the interest of time, to page number 11. And I want to direct your attention, if I could, to paragraph C first. It says reporting screen samples. How long did it take industrial to screen these samples? Do you know?
I believe they are supposed to have a preliminary report within 7 days, I believe.
Okay.
I could be wrong. I haven't looked at this in a while, so.
Okay. Well, these samples were received by the lab. If I'm looking at the certificate of analysis that were introduced in exhibits 1 through 7 by Mr. Bustamante, it says the sample was received at the lab on September 4th, and screening results tests were conducted from September 4th to January 21st. So that nearly 5 months. They're screening these samples for 5 months?
If that's what they sign the affidavit saying, I'm going to say yes.
All right, screening these samples for 5 months, and then after they don't get a report to you until February 11th, am I correct?
That's correct.
Okay, now let's look, if we could, this paragraph 11 contract. It says the screening report shall meet ISO 17025 2017 and RMTC criteria. Is there anything on the certificates that you're offering the stewards to make a decision on that says they met ISO 17025 or RMTC accreditation or criteria at all?
In our rules, it indicates that we do test under ISO 17025 and the RMTC criteria.
No, ma'am, I'm asking, when they did the certificate, is there anything on the certificate that says, oh, by the way, we met ISO 17025 and RMTC criteria in reporting this?
Well, if I had an exhibit I could look at, I could answer that question.
Okay, you don't have exhibits either 1 through 7 before you?
They're on the computer.
Okay, would you take a look?
For time-saving device, I am looking at one of the certificates of analysis, and it does not contain any such language, just for time saving.
Okay, thank you.
So we will
Also,
stipulate to that.
This is the RMTC accreditation standards exhibit 13. This is standard 3.2.5.1. They only have one scientist.
all right, furthermore, I'll just ask you, are you familiar with the RMTC requirements on certificates of adverse analytical findings?
I'm going to say no.
Okay, would you understand this? It's rule 3.2.5.1.1. A minimum of 2 certifying scientists shall independently review all adverse analytical findings and atypical findings before the report is issued. Is there any indication that occurred on this certificate?
Mr.
2
Brewer,
independent.
I apologize. Could you reread that rule number, please?
Yes, it's RMTC 3.2.5.1.1.
Thank you, sir.
No problem.
26 of exhibit 13.
It's our exhibit number 13, page 26. That is not on the certificate. Am I correct, ma'am? No indication there's 2 certifying scientists.
No.
All right. So I want to direct your attention, if I could, to the next page of the contract, exhibit number 9, which is at page 12. And this deals, in addition to the screening, this deals to the final report. It says, final reports and reports of adverse findings shall meet all ISO 17025-217 and RMTC. And it shall identify the method used for confirmatory analysis shall be identified. You see that?
Yes.
Okay. Does in fact the final report have that certification on it?
It does not have the information on the ISO and RMTC.
No, this is your contract. Okay. All right. Let's back up one page, and I'm going to try to slip through as efficiently as I can. Let's go to page 10 of exhibit number 9. All right. I want to direct your attention to reporting and turnaround times, because this has been 5 months since the samples were sent before you got a report. Am I correct?
Correct.
It says the laboratory shall electronically issue screening reports within 5 business days of its receipt of the samples. You produced records to us. There was no communications from the laboratory produced at all. Am I correct?
The initial findings were produced.
What? I'm sorry, ma'am. I didn't hear that last word.
I said there was an initial report that was given to us. I don't have it in front of me, so I can't say what date it was.
Ma'am, I asked for all those records through an IPRA request of Mr. Bustamante, and I repeatedly asked you for these communications. None were produced. Did the lab issue screening reports within 5 business days?
Yes.
What were the screening reports? Since they screened it for 4 months, did the screening reports within 5 days show any chemical?
It showed no violation.
Okay. So the screening reports initially issued pursuant to the contract showed no violations. Am I correct?
Correct.
Okay. Now it says, in the event the lab determines that a screening report cannot be reported as scheduled, they'll notify the New Mexico Racing Commission, provide a justification for the delay, and request the commission for an extension. The extension shall be for a defined period. Did that exchange occur?
Yes.
Oh, so how many times did they ask for an extension, and how many times did the New Mexico Racing Commission provide one?
I would not be able to answer that question because I was not the person that gave the extension.
Who was?
The executive director.
Well, those were requested under the IPRA, and they said nothing existed regarding those communications. Have you seen those communications?
I don't believe there's anything in writing.
Just orally?
Yes.
It says the extension shall be for a defined period of time. What were the extensions for the period of time?
Again, I'm not the person that gave the extension or the approval to give the extension, so I cannot answer that question.
Okay. It says now the confirmatory analysis, and that's what we're talking in these exhibits 1 through 7, these reports, when warranted, shall be completed within 5 days of the screening report. Did that occur?
I don't know how to answer that. It's
I'm
beyond
sorry?
my scope. It's beyond my scope.
What? I'm sorry. Who's making that ruling?
Honorable stewards, at this point, I'm going to object. It's clear that some of these questions are relevant for people other than Investigator Johnson, specifically perhaps Director Ismael Trejo and or the officials at Industrial Labs, the Commission's official lab.
This is very significant as to whether you rely upon these instruments just.
Mr. Brewster,
Yes.
he made an objection. May we answer that objection, sir?
Well, I would like to argue it. I'd like to have my response to it, but if you're not going to let me, I'll
Oh,
assume it's going to be
okay.
granted.
Go ahead, sir. Go ahead, sir.
So my point is, this goes right to the heart on the reliability of these partial certificates. They're not certified. They don't say they comply. They're 5 months after the samples were received. Extensions were granted. We don't have documents for. Absolutely. This questions the very veracity of the conclusions reached in these hearsay reports. It's not irrelevant. It's not beyond the scope. She testified that she knew about all these documents, and she was the one that received them and was familiar with them.
Okay. Are you finished, sir?
Yeah. Well, I have my next question, depending on what you permit me to do.
Well, we're going to grant his objection, sustain it. Go ahead. You have more questions for Ms. Johnson?
Oh, yeah, I have a few. It
Okay,
says,
sir.
let's go back to page 11 at the top. Ma'am, I want to ask you whether these documents were ever sent to you. It says the screening report, and this is C2, shall include the following information at a minimum: the date of the report, the origin of the samples, the collection date, the date received, the date the analysis was initiated, the condition of the samples, the shipping seal, the commission ID number, the laboratory internal reference number, the sample type, the analytical result, the total number of samples, and the analytical methods performed. I did not see such a screening report at all in connection with any of these 7 matters. Have you?
I cannot answer the question because I don't have the documents in front of me. I don't remember if it was a screening report, which would be called a preliminary report, or if we got a final report. I don't have it in front of me. I can say that normally what is on the screening report is on the final report also. So, but I'm not going to just answer something when I'm unsure.
Ma'am, I've asked for the screening reports. We've received 0. There's no screening reports ever sent to us or contained within the materials before the stewards today. Are you saying that you have them or don't have them?
I have one report. I don't know whether it's a screening report or if it is a final report. It has the same information on it.
It doesn't have all this information, does it, at a minimum?
Yes.
Oh, where is that report? Where do you keep it?
It's in my office in the binder under Riadoso.
All right. Now, ma'am, I have, you know what a litigation packet is? Turn to page 12, exhibit number 9. Do you know what that is, ma'am?
I do.
Have you produced those to Mr. Keeton's lawyer or to Mr. Keeton directly?
No, I have not.
Why?
Because I do not have them.
Why?
Because I have not requested them. Well, I have requested them. I haven't received them.
When did you request them?
I don't know, last week, I guess.
Ma'am, I have been asking for these. The first request was in November, asking if there was any lab packets because the money was held up for months.
Right.
No
Mr.
response.
Brewster, you don't understand how the New Mexico Racing Commission works.
I'm beginning to understand.
At the stewards level, never get the litigation package. The litigation package is always requested when we do an appeal.
And we're here to suspend this man in the future and prevent him from conducting his profession with millions of dollars of horses in the barn. I don't know what
Yes,
your
that's
procedure
why
is.
I've requested the package. Okay. I don't have it right now. And, I don't know. Yes, it's been requested, and if they need an extension on getting all the packets together, they will put it in writing and ask for an extension. But as
No.
of right now, it has been requested, and I don't have it.
And the rule, the contract says shall be delivered to the New Mexico Racing Commission no later than 7 days after you submit a request.
hmm
I asked you back in January at the second request to please provide. How many times have I asked you for these documents? And you just now made the request in mid-March?
Objection,
Yes, because
investigator.
it's not, I answered this.
Objection, Investigator Johnson, please hold on. Objection, Investigator Johnson just explained that the normal course essentially is that the litigation packet is not requested until an appeal is filed. However, she did specify that last week she did order the litigation packets, it appears that I don't believe it has been 7 days since that request. So this matter has been asked and answered.
I appreciate the objection, but the point is this. We have a man suspended right here. And he's been suspended now for better part, I want to make a record, for the better part of a month. And the point is this, we've been asking, we just want to deal with the truth. No gamesmanship. We simply want to look at the scientific data and understand how this may have happened. And everybody ought to be in the same line. It's the search for the truth, honestly. And that's all we're interested in. No gamesmanship, no hiding the ball, no extending dates and times for months on end, but to deal with this honestly, openly, and I know the stewards want the same. So if we're just now requesting the packets, there should be no summary suspension at this point. I have one more series of questions, and I'm going to conclude in the interest of time. Ms. Johnson, I want to ask you this. With regard to the chain of custody for either the primary sample or the split sample, do you have a log showing who had access to the samples?
That is not something that the New Mexico Racing Commission has.
Okay.
We have a log of when the horse arrives into the test barn and when it leaves. The official vet could probably answer all of the questions that you will be probably asking in the future. I gave you copies of all the chain of custody documents that I had in my possession.
Okay. The reason I'm asking this is these are the requirements of the RMTC and the ARCI, which New Mexico Racing Commission throughout the rules adhere to. So I'm simply asking whether if you're adhering to the RMTC or ARCI for penalties, certainly you're adhering to the fairness of keeping a chain of custody. So let me ask you this. I would like to put up A2, Exhibit A2, that was mentioned in opening statement to see if we're correct. Next page. Can you get to A2, please? You had it up before, didn't you? A2. And do you have a daily log showing who had access to the sample? The answer is no, correct? Can you hear me, ma'am?
Yes, we do have, there is paperwork that is attached to that. It's also going to be attached to the litigation package.
No, I'm
So,
talking about the test farm, ma'am.
yes, they have a daily log. How do you think that they send the sample numbers to the laboratory? So
Yeah.
they have a sample shipment list that is what you're calling your daily log, I guess.
No,
So
no,
the
no.
answer is yes.
No, ma'am. I'm talking about the daily log of people that interacted at the test barn. The personnel, the assistant trainers, the vets, the vet
Yes,
tech.
we do have that.
When did you produce that in connection with the custody log?
Well, I guess maybe my understanding of your chain of custody and what you're showing here is different. So we do have a daily log for the test barn.
Okay. Do you have the date and time, or the time the sample was sealed?
Yes, it's on the test card.
No, it's not. It has when it was taken, but we don't have the sealing of the sample. Do
It
you have
means the
some other
same
document?
thing. That's the same thing. It's the same. The witness has to watch them put the seal on it, and then they indicate the time.
But is there any indication on a document the time that the sample was sealed, other than
It is on
the
our official test barn document.
right? Do you know when the sample was placed in a secure location? The time.
Objection. I believe that these questions are more appropriate for our official lab veterinarian, Dr. O'Sullivan, who oversees the test barn and is responsible for all this documentation. Investigator Johnson testified earlier. She was not present during the sample collection and also not present during their packing, sealing, packing, and shipping for the courier pickup.
Well, my understanding was she was the only witness going to
That
be presented.
objection is sustained, and we're going to ask Mr. Brewster to move on, please.
Okay, ma'am, I appreciate that. But I mean, if this is their witness to establish the chain of custody and Dr. O'Sullivan's not coming, then they're not going to be able to establish the chain of custody. You can make that as a finding. I mean, if they don't produce the witness to establish the chain and the only one they produce, I cannot cross-examine, how would they have made their point? All right. So given that stipulation, that's all I have for it at the present time.
Thank you, sir. Mr. Bustamante, do you have a closing statement, sir?
You know, thank you, Stuart Smith and Stuart Waxler and Howard. Mr. Brewster, thank you very much. And obviously, we're here today. Essentially, this is the only issue here is the summary suspension, and basically, the issue is whether Mr. Keeton's license should remain suspended pending a final disciplinary hearing and ruling. Obviously, the New Mexico Racing Commission handles things differently. Unlike the situation involved in the, I think, Barry case, the commission has the summary suspension ability, then the summary suspension hearing to see if the summary suspension continue, and then the final disciplinary hearing in which all of the evidence basically is presented and everybody has an opportunity to present their full case. So essentially what we have here today basically is through our exhibits, basically, and specifically the certificates of analysis under Rule 15.2.6.11a, dealing with trainer responsibility, quote, a positive test for a prohibited drug, medication, or substance, including permitted medication in excess of the maximum allowable level as reported by a commission-approved laboratory, is prima facie evidence of a violation of this rule. And essentially, we have presented those affidavits, those adverse analytical findings, basically affidavits, and they each have shown that for all 7 horses, essentially, carmodorol was found in the samples. Now, Stuart, you well know that under Commission Rule 15.2.1.93, basically, at the summary suspension standard is basically if the stewards determine that a licensee's actions constitute an immediate danger to the public health, safety, integrity, or welfare of the horse racing industry, the stewards may summarily suspend a licensee. Again, it's a license issued by the New Mexico Racing Commission is a privilege, not a right. So therefore, applying the facts that we've heard here today, basically, to the summary suspension standard, we are dealing with 7 positive results on a single day of racing, and an incredibly important day of racing involving millions of dollars. Essentially, 7 medication violations. Clearly, that is a health and safety and welfare concern because it puts those horses that have been drugged for financial gain, it puts them in danger. Also, if those horses are allowed to run competitively in races, essentially it puts the other horses in those races as well as the other jockeys in danger as well. The situation that we presented to you today, Honorable Stewards, it's also basically a situation of integrity. Basically, there's a prima facie case of improper medication in a horse, and that essentially is cheating the betting public and the fans of the sport. It's a black eye to the reputation of horse racing nation and worldwide, a black eye to the Riadoso meet that was held at the Downs of Albuquerque, and essentially a black eye because it's allegations of the unfortunate drugging of innocent, beautiful animals solely to gain a competitive advantage for financial gain. Moreover, the evidence indicated that split testing has been requested, and that process will I believe, take place tomorrow. That could confirm the adverse analytical findings of the commission or could refute those official results. So therefore, all of those reasons, Honorable Stewards, are reasons why we believe the stewards should determine that the summary suspension on Mr. Keeton should continue. Thank you very much.
Thank you, Mr. Bustamante.
All we have, ma'am, are 7 certificates, letters from industrial. After 5 months, that's all we have. 5 or 7 letters from industrial. And no indication how the analysis was performed. No indication that they could distinguish this from 8 other identical compounds through their testing. No indication why they took 5 months to screen. Come on. But the question I ask, if there was nothing, I mean, there's no chain of custody here. The splits are, there's no connection between the primaries and the splits except a number. There's no indication anything about the chain of custody. It was established consistent with RMTC or ARCI. But even if we assumed that these samples were properly taken and documented through a chain of custody, 5 months of screening, no lab packets. But the most significant question asked was in the first 2 questions I asked Ms. Johnson. Do you have any evidence whatsoever that Toby Keeton took any action or done anything to administer this medication to a horse? And the answer is no. So the New Mexico rule is very clear, and you can't ignore the rule. The fact that somebody says this is what we do in New Mexico doesn't make it right if you're not abiding by the express law of due process and rule. And the rule says this. It says the stewards shall, all right, so I'm sorry. It's actually it's the proceedings before the stewards. If the stewards determine that a licensee's actions, what action? What evidence do you have that he in any way acted to administer this medication? There is zero, none. And I said, did you interview anyone? Did the lab tell you anything about the administration? Did you any evidence whatsoever? No. So what you have to do if you suspend him is you've got to disregard this rule. You've got to say, well, even though there's no actions that we know, we're just going to suspend him anyway. Now, there are a lot of rules for trainers to follow, a lot of rules for jockeys and hot walkers and licensees, but there are rules for stewards to follow too. And we have to follow those. There's no evidence of any actions. Now, Mr. Bustamante wants to say, well, if you find it, it's automatically absolute insurer rule. The absolute insurer rule holds trainers responsible for a positive in a horse, and they can be fined But they cannot be summarily suspended on the basis that the public's health, safety, and welfare is going to be impacted unless you have the actions of a trainer. There's no presumption. There's cases, we've got them in our papers. Mr. DeAngelo cited them to you. There's no cases that say you can summarily suspend someone when they took no action to affect anybody's health, safety, and welfare whatsoever. There's no evidence that he's cheating or hurting beautiful animals. That's nonsense. There's no evidence of that. Look at the extraordinary circumstances here. And I mean, he's lots of press. Mr. Bustamani's been interviewed. I've not. But lots of press on Mr. Keeton, suspended. But 5 months of screening, no screening reports, no compliance with the contract on the details of 17025 or the certification of scientists, no production of the underlying lab data to allow our scientists to look at it and give their viewpoints. You can't continue the summary suspension. As much as the commission might, through Mr. Money, want it, or Mr. Trotter wants it, or Mr. Smith wants it, as they've told others, you have duties and responsibilities to follow the rule. The summaries, I don't know what the summary suspension was granted on. Now that I see all the evidence in the light of day produced to us, it's just like something from a report from the industrial lab, and nobody said, let's look behind it. The summary suspension must end. And then we request an immediate hearing, the production of discovery and a hearing, and stop the gamesmanship. We've asked for a split. Guess what happened? The split rule, and since he commented in this closing argument, provides that and New Mexico is really fair to a trainer. The New Mexico Commission must produce 3 laboratories for a choice. Choice 1, choice 2, and choice 3. Then the trainer, let me read the rule specifically. It says this, and this is very important because he's trying to short sheet us and prevent us from getting a split. The storage and split samples, it's under 15.2.6.10. And it says, after receiving a written report under D2 of that rule, the trainer, the commission shall provide 3 laboratories for him to select from. The trainer shall then select his first choice, second choice, and third choice of laboratories for the split. And then he can select it, and then it must be shipped within 7 days of the trainer's request. And then it says this, it says the trainer, owner, or designee, this is Mr. Keeton, shall confirm the split sample laboratory's willingness to provide the testing requested. What happened here? They said, well, you're only going to get UC Davis. UC Davis is embroiled in the same testing for Texas. They're totally conflicted. We want a lab that's neutral, not biased or partial in any way, that will honestly apply the science to this. And it's Mr. Keeton's right to select the lab that can do that. They've told us you've got to send it UC Davis, or they're going to, we're going to get rid of the splits. Outrageous.
Mr. Brewster, may I interrupt here, sir? This hearing isn't about split samples. This hearing is about whether this licensee shall remain suspended or not. Stewards have nothing to do. Stewards have nothing to do with the split sample process until it comes before us after the fact. We're not going to make a decision on split sample rights at this point in time. So I'm just saying, if you want to do your closing and bring up all your points that you want us to consider, we'll be more than happy to do that. But it needs to pertain to the samples here that we're talking about today, not split sample rights.
Well, you didn't interrupt him when he said we're going to do the splits tomorrow. What I'm saying is he knows I have a conflict. I'm in depositions in Texas. I cannot be there tomorrow. So the point is, you don't be there, you lose your split. That's outrageous. The stewards
Sir?
need to give us some direction. Who else do we talk to? Mr. Trail.
That's up to, number one, as I just stated, it's not up to us, but it's the trainer's responsibility to make himself available and or a representative, as far as I understand. And that's as much as I'm gonna hear on this.
Well, ma'am, hold on now. Wait, he has a right to pick the lab. They've not given him a
Sir?
choice.
Sir, I told you we have nothing to do with split samples on this case that we're listening to this morning, okay?
I appreciate that. I was just looking for fairness, okay? And I thought that maybe this would be the body that would render that. Okay, that's all I have.
If
Oh,
you have,
we've supplied our exhibits in the interest of time, exhibits 1 through 23 to the stewards for their consideration. We'd move them in at this point. We can send paper copies. Friday
Okay.
was, thank you, ma'am.
okay, we'll allow those exhibits in 1 through 23. Thank you, sir. At this time, we're going to go, the stewards will go into deliberation, and we'll be back in touch with you once we examine everything before us today. Okay?
Thank you, ma'am. Would that be today? Are we relieved? Will you contact us later, or how should we do that?
Well, you need to get your documents to us, don't you, sir?
Yes, we'll do it pronto. Friday, huh?
The electronic
Okay.
version.
We sent them all to you electronically. We'll send paper copies by FedEx tomorrow.
Okay.
We tried to do it
All
Friday,
right,
but we
we'll look this over and get you a decision as soon as possible. And after we make a decision here today, if there is a hearing to be set, it will be set within 10 days of this hearing today.
thank you. That's very nice. I appreciate it. And I appreciate all your attention here on a Sunday. You've been very kind to us. Thank you.
All right, sir, thank you. Okay, that's going to conclude. There. Okay, there's Mr. Blackburn. I see you.
Okay. Richard Bustamante is present too, and we are recording.
Okay, we're back on record in the case of Mr. Toby Keeton. And time is approximately 11 a.m. Present with us on this continued hearing is Mr. Blackburn. He's local counsel, and he's going to be representing Mr. Keaton's lawyer, Mr. Brewster, today in this final portion. And we have Mr. Toby Keeton present, as well as Cindy Keeton, Lisa Johnson, and also House Counsel for the New Mexico Racing Commission, Richard Bustamante, and the stewards. Okay, we have come to a decision in this matter this morning. At this time, Mr. Keeton will remain suspended, and there'll be a disciplinary hearing scheduled for Mr. Keeton. It will be scheduled for Tuesday, March 25th at 10 a.m. Notices will be sent out, and the time and place is Sunland Park Racetrack, and or they'll send out a team reference for you. And that will conclude this hearing this morning.
1 second.
So we just said a discipline.
Okay. Recording has stopped.